Mr. Speaker, Order 20 is clear that the Speaker shall uphold the honor, dignity, and sanctity of the House. Mr. Speaker, the maker of the statement has been convicted by a High Court. Convicted by a High Court. I have read it in the papers. I have read it on social media. And he wants to come and stand in this chamber and make statements so that this House will be telling the courts that it doesn't matter what you do. Mr. Speaker, it doesn't uphold the dignity and honor of this House. It doesn't uphold the dignity and honor of this House. That he has been convicted by the courts, and indeed, the basis of his conviction is a conduct in this chamber. The basis of his conviction is the conduct in this chamber. When he was cautioned that if he insisted and had himself sworn in as a member of parliament in the face of a restraining order by a court, if the court came after him, he would be accountable alone. We will not be part of it. This was made very clear in this chamber. And he took it upon himself to take the risk. And then he was ready to take responsibility for his conduct. Mr. Speaker, it's time for him to go and account for his conduct. But to come and stand in this chamber and we will all participate in sitting here and listening to him make a statement as if the courts are nothing. Mr. Speaker, I'm not ready to be part of it. So I have strong objections to him reading a statement in this chamber because the courts have convicted him. He should go and appeal against the conviction, have it set aside, and come back. And we have a duty as a House to uphold the dignity, the integrity, and the respect of our courts and the rule of law. He is aware. Your leader on several occasions told the Speaker that even if he was not served, once he became aware of a decision of the courts, the Speaker must act on the basis of becoming aware. So it's not a question of whether he has been served. He is aware that the courts have convicted him. He is aware that the courts have convicted him. And he wants to come and stand in this chamber and make a statement. I caution. I said, don't do that. Don't make a statement. So, Mr. Speaker, we have strong objections.
Mr. Speaker, with your indulgence, if I may read, civil or criminal processes coming from any court or place not of Parliament shall not be served or executed in relation to the Speaker or a member or the clerk to Parliament while he is or on his way to attending or returning from or any proceedings of Parliament. Mr. Speaker, the standing orders, Mr. Speaker, even does the job. Starting from Order 25, which is titled Matters Relating to Criminal Processes. Mr. Speaker, it is very important that we emphasize that contempt proceedings are quasi-criminal. In other words, it is like criminal. Mr. Speaker, when you look at Order 25.3, it says that where a member of or the clerk to Parliament is convicted by a court of competent jurisdiction, the registrar of the court shall within 12 hours after the conviction inform the Speaker of the conviction. Mr. Speaker, do you have any notice from the court? No. Mr. Speaker, do you have any notice from the court?
The honorable member who just spoke, he cited Order 25 of our standing orders. Mr. Speaker, Order 25, 24 deal with the service of processes. We're not talking about the service of processes. We're not. Mr. Speaker, secondly, Order 25 talks about detention. Subject to Order 24, where a member of or the clerk to Parliament, where a member, please listen, where a member of or the clerk to Parliament is restricted, detained, or arrested, the person responsible for the restriction, detention, or arrest shall within 6 hours of the restriction, detention, or arrest inform the Speaker of the restriction, detention, or arrest. Has the man been arrested? Has he been restricted? Has he been detained? So how does Order 25 come into play? Mr. Speaker, here we are talking about, Mr. Speaker, here we are talking about a conviction. A conviction. He has been convicted. He has been convicted. Mr. Speaker, I know because he is defending his right to speak here, because he says that even if he has been convicted, if we have not been properly served, then we should not deny him a right to speak in this chamber. That's what he's saying. He is not denying that he hasn't been convicted. Nobody in this chamber is denying that he hasn't been convicted, because they know he has been convicted. It is public knowledge. It is common knowledge. It's been covered widely by the media. And my argument is that this house must respect a coordinate branch of government. We will not arrest him and hand him over to the judges. We will not arrest him and hand him over to the prisons authorities. But we will not condone him coming here and boldly making statements on the floor of this house as if we don't care about the judiciary and what they are doing.
Mr. Speaker, I was watching proceedings from my office, and I heard you call the member for Akwatia to make a statement which you've duly admitted. Upon calling his name, the majority leader and leader of government business rose up, relying on Order 20 and Article 127 of the Constitution. He argued. First leg of his argument, inviting you to uphold the dignity of this house and generally to help in respecting the independence of the judiciary. Let me say that those submissions he made, though are legal submissions, but I find those submissions very rich in the context that he submits same on this House floor. Mr. Speaker, first, the applicant. In October 2024, a matter arose regarding some vacant seats. I, as a leader of government business, feeling dissatisfied, and upon reading the Constitution, felt that the right place and forum was the Supreme Court. Mr. Speaker, the majority leader, who was a de facto legal advisor to the then minority front bench, was very much aware of the matters in issue. I first sought an ex parte relief. I first applied to the court, invoked the jurisdiction of the court through an ex parte application, and made all the matters known to the court, and the court ruled in my favor. that order of the court staying the decision of the Speaker, which stay of execution allowed the majority to stay in its place, was forcefully challenged with all the energy from the majority leader, who was the de facto legal advisor to the front bench. Mr. Speaker, his side did not respect the Supreme Court. Mr. Speaker, in fact, physically, they moved in to occupy the seat of the majority. Mr. Speaker, after that, the issues were determined after parties had filed. Mr. Speaker, parties filed all their written submissions and argued in court.